I really think some independent membership on an ethics committee can help. And I ask you to please consider it. It will also help rebuild trust in Reston, which you all deserve. And this is not personal. This is about the future. You know, this is about who may come next on the board. Thank you.
Thank you, Connie.
All right. Rick Hamilton?
I don't really have much to add to what Connie said. I live on Thunder Chase Drive, Polo Fields.
Can you tell me the exact address?
12629 Thunder Chase. Yeah, I got an email from Tammy alerting me, and I was a little surprised and didn't understand why there wasn't broader dissemination of this meeting to all the members. But that aside, I think Connie's right. I think we have a lot of smart people who are residents here who ought to be involved in this process. I would be very much opposed to hiring a bunch of consultants to do this for us. I think we need to govern ourselves. And maybe we need a consultant to help us guide us through the process. But I think this is something we need to handle internally by folks who live here. Thanks.
Thank you.
Thank you. All right, that's those that have signed up. Is there anybody remaining in the audience that would care to speak? Yes, sir. Come on up.
My name is Erwin Flashman. I live at 1327 Buttermilk Lane, Reston, Virginia. For this evening, I thought I would try to find some quote from Robert Simon and use it to persuade you that an independent ethics committee, apart from the governance committee, was something that should stand by itself, and that it was a useful thing in the eyes of its founder. I haven't found such a quote, unfortunately, but it doesn't make it any less valid a proposition. The kinds of things that will occupy and have occupied the members of the board to date have allowed things such as the conflict of interest statements to go unexamined for months. And even after they have been resubmitted, reconsidered by those who submitted them, there are still some questions that could come up about those that were submitted. People who will occupy the seats on the governance committee are all here. Why their view or perspicacity should change is beyond me. You need to have new people, people who have fresh eyes, who bring something more than merely having been elected to the board, but who have some special cognizance of what ethics are about, and are able to apply it and give the benefit of their wisdom to the board. And the board should be open and accepting. They retain the final voice and vote. But you need to have assistance in this matter. Otherwise, it's just going to fall through the cracks. The governance committee has a lot of very important things to do, and they will put their attention on those matters, and not on ethics. But ethics is important. It gives you a foundation from which to operate, and to be like Caesar's wife, not only above reproach, but to appear to be above reproach. Thank you.
Is there anybody else? All right. And we'll close member comments. And we will move on to Mr. Chadwick. What's your first on the agenda?
Since we really didn't have a session on board duties and responsibilities when you first got elected during the course of the year, I did want to, especially for the newer board members, I want to make sure that we have the opportunity to go through some of the issues in terms of your responsibilities and duties as board members. I first want to point out what a board is. And in your case, you're a board of elected individuals who are elected to the board positions of a non-stock corporation. The non-stock corporation is an entity created under the Non-Stock Corporation Act. It provides, God bless you. It has its own statutory section, and it requires that all corporate powers of the corporation shall be exercised by or under the direction of the corporation's board of directors. Not surprisingly, that same sort of provision is set forth in the Reston deed as well, that the board of directors is responsible for, in essence, managing the affairs of the association. The buck stops with the board. You make the decisions, you listen, you deliberate, and your ultimate responsibility is to make a fully informed decision. Board responsibilities, large measures stem from statute as well as your documents. Managerial oversight, you're responsible for making sure that the affairs, the business affairs, the operation of the association are met. However, the daily operations of the corporation are typically handled by staff or the corporation officers on a day-to-day basis. But ultimately, the responsibility falls back to the board of directors. You can delegate authority to your officers that you elect from your membership on the board, to staff, to the CEO, to your accountants, to the attorneys who work with you. But you can't delegate the ultimate responsibility. The responsibility for the actions taken by this board are your responsibility. Generally speaking, according to case law, there's an expectation that officers and directors as corporate fiduciaries exercise the utmost good faith and loyalty in their dealings with and on behalf of the corporation. This is also set forth in the Virginia Non-Stock Corporation Act at section 13.1-870. And I really want you to pay attention to the italicized part at the bottom. A director shall discharge his or her duties as a director in accordance with his or her good faith business judgment of the best interest of the corporation. It's important to note that you've got a couple of responsibilities there. One is to exercise your judgment in good faith, your business judgment. It means you bring your background, your knowledge, your educational background, your experience to the table. You make sure that you have a voice amongst your fellow board members to discuss the issues at issue. The other side of the coin, though, is that you're exercising those business judgment in the best interest of the corporation. That's right out of the Non-Stock Act. It's the corporation first. Your duty of loyalty and responsibility is to the entity, because under Virginia law, the entity is a recognized legal person, and as such, it's the corporation to which you owe the first duty of loyalty. Board duties, there are basically four. Duty of care, making sure that you are acting reasonably under the circumstances, that you have the information that you need to make reasonable business decisions, as we've just discussed. There's the duty of loyalty, there's the duty of fiduciary, and ultimately the duty to act. Duty of care, good faith, business judgment, making sure that you have the information you need to make the decisions. If you don't, then you ask for your staff or your professionals who work with you to get the additional information so that you can ultimately make what is known as a fully informed decision. Your responsibility is, once again, to make good faith business judgment in the best interest of the corporation. A reasonable degree of care, you're going to be held to a reasonable degree of care by the courts, and prudence in the protection and the management of the corporation and its assets. You should be constantly aware, both within your workings within the community as well as with your discussions with the various members that you exchange pleasantries with from time to time, what issues are of import to the association, what issues are of import to the members. And if there's something that you become aware of that you feel is or could put the association in harm's way or needs to be brought to the attention of the association, it is important that you do so. There is a concept called constructive knowledge, and it has been used in situations where if one director is aware of an issue in a community, then that information is imputed to all the rest of the board members, whether they actually know or not. So having one board member know means that the board knew or should have known. And it's important for your protection, for your information, that if you're aware of something, whether it's a potential slip and fall case, whether it's an issue regarding one of the common areas, an event that took place at the pool, whatever it is, that you bring that to the attention of staff and of the board ultimately, so that the board is aware of it and can make decisions with regard to that. That's the duty of care. Duty of loyalty means that you are elected to the positions you fill on the board, but you also have a duty to the members collectively. You're here to make the decisions on behalf of the association that protect the interests of the association, to make sure that you're acting with undivided loyalty to the association. There's no conflict of interests. There's no issues where you're self-dealing. We'll talk a little bit about what the statute says about conflicts of interest shortly, but realize that your duty of loyalty is first and foremost. So when you have an issue, or if you have a conflict, the most important thing that you can do is to disclose it, as we'll see under the statutory language shortly. Fiduciary duty, this is oftentimes confused with all these other duties, but the fiduciary duty of a board member is really to monitor the physical assets of the association, as well as maintaining the fiscal well-being of the corporation and the assets of the association, making sure that they're well used, making sure that they are sufficient for the needs of the association, and maintaining the properties that you do own. Ultimately, though, and the thrust of most of the common law case law that we see coming out of the Virginia Supreme Court and other jurisdictions, your responsibility is to act. Once you're put on notice of an issue, you have an obligation to act. Now, that may mean ultimately that you decide to do nothing, but it's the decision that counts. It's the addressing of the issue, the discussion that occurs at the board meeting, the fully informed decision that you ultimately make that's important. And it may mean that you don't take any action, or you dictate to staff that no action is to be taken on this. Make sure it's in the record, make sure it's in the minutes of the corporation, because that's going to be your protection down the road as well. But that's your responsibility, to act and ultimately to lead. You lead the organization. You lead and set a direction and a tone for the association, both in terms of direction, but also in terms of your ethical backgrounds as well. Virginia is not necessarily unique, but it does have an interesting conflict of interest provision, which is in the Non-Stock Corporation Act. The most important thing under this provision is disclosure of a conflict, so that the rest of the board members know what that conflict exists, because then they are, one, aware of that, and two, can make a fully informed decision based upon what it is that they know. And so they can take that conflict into consideration. Ultimately, though, the fairness of the decision and the fairness of the contract or whatever you're dealing with to the corporation is paramount. And interestingly enough, under the provisions, and it's a little convoluted the way they have it set up, but the reality is that the disinterested directors can themselves pass an issue where there is a conflict of interest, even though it may not meet the quorum requirements. The disinterested directors, in fact, are considered to be a quorum in and of themselves if there is truly a conflict of interest. So realize that under Virginia's statute, disclosure is paramount, making sure the rest of your board members know there is either a potential or an existing conflict of interest, and then determining by the vote of the board or the rest of the board of those disinterested whether or not the action can go through. So realize that Virginia statute has a conflicts of interest provision that does apply directly to you as a corporation. Ultimately, what you're going to be evaluated on as a board by the courts is the business judgment rule. Have you exercised any action that you've taken in good faith? And generally, the business judgment rule is not going to, the court is not going to substitute its judgment for a board of directors. The board is considered to be in a position of knowledge, information, to be able to make a decision on behalf of the association or the corporation. And as long as you're acting in good faith, you're reasonably informed of the issue at hand, and that you rationally believe the action taken was in the best interest of the corporation, that's the standard. And that's what you're going to be judged by. And that's what a court's going to look at. And generally speaking, unless there's something wrong with any one of those points that the court becomes aware of through testimony or facts, the court is not going to substitute its judgment for the board's, because then it would be sitting in the board's position and not the board. So realize that that's your responsibilities, your duties, the responsibilities that you have to the corporation first, the members second, because there are times when the members' interests are not always going to be in line with the corporation's, and you serve as a board to make sure that the interests of the corporation are first protected. Here ended the sermon for the day. Brief to the point.
Amen. Questions? Ken, could you, I'm not sure I understand the meaning of the term disinterested member. Could you?
It's one that doesn't have a conflict of
Does
interest.
not have a conflict of interest. I see.
So it's disinterested versus interested. Interested meaning there is a potential or a real conflict of interest.
Thank you.
I think there's been some questions around what is a conflict of interest.
And that's
I know
like
it's-
the great Supreme Court justice said about pornography.
Right.
You know it when you see it. The reality is that there's not a good definition, and it really is fact-based. Obviously, if you have a monetary interest in a contract, or you own part of the contractor that is seeking to contract with the corporation, that's a conflict
Right.
of interest. If you're going to pecuniarily gain directly from a situation, that could be, dependent upon the circumstances, a conflict of interest. But you also have to weigh and balance what we're talking about in terms of the context of the issue. Just because it will benefit doesn't necessarily make it a conflict on an individual board member. So it depends on a case-by-case basis what you're looking at.
You go around the table, Danielle. Do you have anything? You have anything? Rachel, you're looking at me.
I got my question in. Thank you.
All right.
No, I'm good.
Good. Thank you, Counselor.
No problem, no comment.
Okay.
I'm good.
All right. Ken, anything else?
Thank you for having
Kate?
me.
All right. Why don't we move on to Rachel? This is your opportunity, your proposal on the establishment of an ethics committee.
Thank you, Mr. President. Thank you.
Thank you,
I'll
sir.
give me a moment to see if I have the right pair of glasses for this activity. I think I'll have both of them with me so I can be flexible. Thank you.